So friends, there's a new development in Donald Trump's Georgia State RICO prosecution, a ruling allowing Donald Trump to appeal a recent order entered by Judge McAfee. But friends, this one is really not as concerning as it might seem. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, there's an interesting new development in Donald Trump's Georgia State RICO prosecution. Now, I'm calling it interesting, and I know some people saw it and called it upsetting, frustrating, infuriating. I want to spend a few minutes talking about this new development and trying to explain why I don't see it as all that concerning. Let's start with the new reporting. This from NBC News. Headline: Georgia judge gives Trump permission to appeal order keeping DA Fani Willis on election interference case. And that article begins, a judge on Wednesday gave former President Donald Trump and 8 of his co-defendants permission to appeal the order allowing Fulton County District Attorney Fani Willis to remain on the Georgia election interference case despite their allegations of misconduct. Fulton County Superior Court Judge Scott McAfee granted a certificate of immediate review, citing Trump and his co-defendants' argument that McAfee's decision to keep Willis on the case is of such importance to the case that immediate review should be had. McAfee ruled last week that Willis would be allowed to stay on the racketeering case she brought against Trump if Nathan Wade, the special prosecutor she appointed, resigned. Wade resigned that afternoon. The defendants could not directly appeal McAfee's decision at this point in the case, so they had asked him, the judge, to approve a certificate of immediate review, which would put the matter before an appeals court. The ruling gives the State Court of Appeals 45 days to decide whether to hear Trump's appeal of McAfee's order once the appeal is filed. The attorneys have 10 days to file the appeal. If the appeals court agrees to hear the appeal and then decides to disqualify Willis, that would upend and delay the sprawling prosecution for at least months while a new prosecutor is selected to take over the case. And friends, before we talk about why I don't think this is really all that concerning a development, let's first have a look at the Georgia state law that applies to this situation, and then let's turn to Judge McAfee's very short order. First of all, the Georgia state law involving certification required for immediate review of non-final orders, decisions, or judgment reads in part as follows: in any appeal under this chapter where the order, decision, or judgment is not final, it shall be necessary that the trial judge certify within 10 days of the entry thereof that the order, decision, or judgment is of such importance to the case that an immediate review should be had. And here is some of Judge McAfee's very short order that he just issued. Upon review of the defendant's joint motion for a certificate of immediate review, the court finds that the order on the defendant's motions to dismiss and disqualify the Fulton County District Attorney, issued March 15, 2024, is of such importance to the case that immediate review should be had. Accordingly, the requested motion is granted. Now, friends, I don't want to bury the lead here because I have not yet read you the most important sentence in Judge McAfee's order, and it's the sentence that leads me to conclude that this is not all that troubling a development. Here is that sentence. The court intends to continue addressing the many other unrelated pending pretrial motions, regardless of whether the petition is granted within 45 days of filing, and even if any subsequent appeal is expedited by the appellate court, so ordered this 20th day of March, 2024. So friends, 4 important takeaways. 1, and most importantly, this case remains on the trial track. Judge McAfee said, we're going to continue litigating motions. The train is not stopping, the train is not slowing down. It will proceed on a trial track. We will keep moving toward a trial date. Of course, we don't have a trial date set down in Georgia yet, but Judge McAfee is not letting up. That's what's most important. Now, he did grant this motion, and ordinarily, a defendant in a criminal case can only appeal at the end of the case, after he's been tried, convicted, and sentenced. That's when his appellate rights come into existence. That's when they're born. And that's when a defendant can appeal everything and anything a judge has done, from the earliest rulings in the case, including his denial of their request to disqualify Fani Willis from the case, through every single thing he does during the course of the trial, how he resolves motions, his rulings on evidence, his jury instructions. But it's not until the end of the case that criminal defendants can generally file their appeal. But the laws of Georgia have this unique provision. They say, if it's a really consequential ruling, then the judge can issue this certificate and allow for an early appeal of that one issue, that one ruling. Scott McAfee said, have at it, Donald. You go ahead and file your little appeal. Keep yourself busy. The trial will continue moving forward. We will keep litigating, resolving motions on our way to the trial date. That's the first takeaway and the most important takeaway. 2, the fact that this case will remain on the trial track distinguishes this case from what we're experiencing in D.C. in the federal prosecution of Donald Trump for trying to overturn the 2020 presidential election, because that one came to a dead stop, a grinding halt, because the Supreme Court has that issue on appeal, and the procedures are different in the federal system than they are down in Georgia. So this development is very different than the development in Donald Trump's federal case, which, yes, is infuriating and frustrating, because that case should have started in trial on March 4. But Donald Trump is, gummed up the works, and now Judge Chutkan is in a holding pattern, just waiting for the Supreme Court to give her the case back so she can get it back on the trial track. So very different developments in the D.C. case versus the Georgia case. 3, Judge McAfee made the right decision. He ruled correctly, in accordance with the law, in accordance with the facts that were developed during a lengthy evidentiary hearing. He ruled that Fani Willis and her office are not disqualified from this prosecution. That was the right ruling. It's correct. It's supported by Georgia state case law. So let the appellate court have at it, because they will affirm Judge McAfee's ruling that Fani Willis should remain on this case. And here's the thing, friends. The appellate court doesn't have to accept this case for review. Maybe they will, maybe they won't. Maybe they'll look at the record and said, no, we're not going to disturb this ruling by Judge McAfee because it was right. We don't need to litigate it in the appellate court. But if they do take it up, they will affirm Judge McAfee's ruling, I predict. But 4, what if they didn't? Stay with me here. Let's assume Judge McAfee refused to issue this certificate of review, didn't let Donald Trump appeal this important issue, this important ruling right now, made him wait until the very end. What would that mean? Well, that would mean Donald Trump would go through a trial, would be convicted, because he will be convicted when these cases go to trial, based on the evidence we have seen. He would be sentenced, then he would appeal anything he wanted to appeal that happened during the course of the trial, including this pretrial ruling. And if the appellate court decided that Judge McAfee was wrong, you know what would happen? They would bust the conviction. They would reverse it. They would throw it out. And then we are all back to square one. So frankly, this is an issue that I'm okay with the appellate court looking at right now, because they should affirm it. They should not even bother taking it on because there's no reason to. But if they do, they should affirm Judge McAfee's ruling. But again, I'm going to finish where I started with takeaway number one, the most important takeaway. This case remains on the trial track. And it's a trial, it's a train that's not going to pull into the station anytime soon, right? The station accountability, next stop, but that stop is a long way away. It's like a cross-country trip and then some, but we're going to get there. We're going to get there in all of Donald Trump's cases. I believe that to my core. We're not going to get there soon enough. We're going to get there in the ugliest way imaginable. We've already experienced a lot of that, but we're going to get there. We're going to get there. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.